section where we'll be covering some stuff that actually matters somewhat to the new version of the DD2648, specifically line 11K. So, first of all, you're going to go to this website, ESGR.mil, and they have a non-standard, supposedly secure certificate. I don't buy that. So what we're going to do is we're going to talk about ESGR. And this group is known as the Employer Support of the Guard and Reserves. So this organization, what they do is they fight on your behalf if you join the reserves, and let's say if you have any sort of employee-employer issues. Because let's say you do join the reserves and then you get called to deployment or something. You have certain protections to your job. For instance, if you are called away for a certain amount of time, while you're gone, you have to be eligible for consideration for advancement. Now, eligible for consideration for advancement doesn't mean they will advance you. It just means they have to throw you in the ring and say, hey, what about this guy? That's pretty much that. Now, there are some other protections, and it's been a while, so I can't remember all of them. But if you wanted to learn more information, there's this website right here. The Department of Labor has a specific website with all the information you ever wanted to know about USERRA. And if you click on Know Your Rights, right here, am I covered under USERRA? What is USERRA? They give you the specific things you have to do. Let's say if you're gone for 31 days, maybe up to 6 months or more than 6 months. What are some of the things that you have to do to protect your job? Because even though you do have protection, there are certain steps that you have to take in order to actually protect your job. So, let's see here. If I remember correctly, now I can't find the exact case for this, but there was a case in which let me start with this one here. This one I actually do have a case for. Olds versus Charles Schwab. So in this situation, now the thing I can't find is the original article that I found this under, but what happened was Olds was a reservist, and they were working for Charles Schwab. Now, according to the article, what had happened was Olds went on deployment, came back from Afghanistan, and because Charles Schwab was the job for Charles Schwab was commission-based only, Charles Schwab said that we fulfilled the USERRA requirements by rehiring you in this position, but you have to rebuild your contacts. Now, according to USERRA, you have to be guaranteed a position in your company. Not necessarily the same one, but a position that pays at least the same that you made before you actually left for deployment. And Charles Schwab argued that because everything was commission-based, they didn't owe him a penny. So, Olds went to court with these guys, and after a certain bouts, things went into arbitration eventually, and Charles Schwab supposedly ended up paying the guy $3.2 million or something like that. I can't remember the exact amount, but in terms of the amount of time that they wasted, the lawyer's fees, it was not worth Charles Schwab's time and money. At some point, I think Ulf still wasn't satisfied, and he actually tried to sue Charles Schwab again for taxation stuff, but that didn't go through and it got thrown out. So there you go. There's one case where USERRA worked out in someone's favor, even though the case had to go to arbitration and didn't go through the actual court decision or anything. It still at least worked out in his favor. Now, there was another case, which I cannot find, where supposedly it was a National Guardsman who had hated his job, and then he went on deployment. Whoop-de-doo, right? You escape one job and then you go to another job that you hate. So he gets back from his deployment and then he's like, hey, I want my job back. And the company's like, well, no, we're not going to do that. So they go to court and it didn't work out in his favor because before he had left, he had sent out emails from work to some friends and some family saying how much work sucked, how much he couldn't wait to go on deployment. So one of the stipulations with protection for your job of USERRA is that these deployments are not voluntary. So if you are being involuntarily recalled by the service to go on deployment, then you're protected under USERRA. But because he sent these emails out saying how much he hated his job, the courts determined that these deployments were not involuntary, that he had actually volunteered for the deployments. So in that case, the courts upheld the company's decision to fire that guy. So lesson be learned, if you're going to complain about your crappy job, don't do it over work email. Simple as that. And that is pretty much USERRA in a nutshell. So that section pretty much covers 11K in the 2011 version of the DD2648, and that corresponds to part of line 17 on the 2016 version of the 2648. There's also a little bit more we're going to cover with line 17. We'll get to that in a future video.